Good afternoon and welcome to our February members meeting. I'm Rick Meredith, the president of Capital Crimes, and we have a great guest today. And we're so thankful that Terry Dwyer agreed to speak to us. He will discuss many legal issues facing writers, from copyright laws to the pitfalls of setting up an independent publishing company. Terry is the founder of Legalese for Writers. I hope you all saw the email to submit questions for Terry. If not, put them in the chat and Karen will ask them during the Q&A. Before we begin a presentation, I have a few announcements to share. First, late last month, we desperately needed an attorney to help us after our 20 years with our old bank decided to close our account. The rationale was that we are a nonprofit, but not on any state or federal register. When we explained that we are and have always been an unincorporated association, is bolded even on our annual report we submit to the bank when we have new officers on board. It was just deaf ears. Our problem was we had members sending in money for renewals, but had no place for it to land. And after a few days, it would go back to the member. But with the help of Chris Dreith and Harriet Fox and Jennifer Morita, we scrambled and found two banks. We finally chose the Poppy Bank. Fortunately, it's only about a block from me. The staff was, cordial, understood our situation, and they had very good rates. So crisis was averted, and many thanks to Harriet and Chris. On a brighter note, I just checked today, we're up to 143 members with 33 laps, and we'll be sending a renewal nudge soon. Really good news is Left Coast Crime begins next Wednesday in San Francisco. Our very own Robin Bursell is a guest of honor, and we have over 40 members on panels. We also have 8 nominees for Lefty Awards: Diane Schaefer for debut novel, Claire Booth and James Latoile for best novels, Claire M. Johnson for historical mystery, and Jennifer Chow, Elizabeth Crowns. I'm sorry? Katrina McPherson and Cindy Sample for best humorous mystery. Not bad. Congratulations and good luck to all. And if you haven't already heard, A Face in the Book will be closing its doors in March. Last Sunday, the board presented a letter of appreciation to Tina Ferguson and her staff for all the support they provided to Capital Crimes and our authors for the past 15 years. They will be missed. Also, we donated $200 to the Sacramento Literacy Foundation in memory of Pat Canterbury, who was one of the Capital Crimes founders. She was instrumental in starting and promoting the foundation's Authors on the Move fundraiser. And if you're looking to donate in Pat's memory, the Literacy Foundation is a very worthy cause. Let me go over a few of our upcoming events. You can find the details on our website or in the newsletter. On Tuesday, March 10th, our Meet the Author interview is with Claire M. Johnson, again, another one of the nominees for Left Coast Crime. On Saturday, March 21st, our members meeting will be forensic psychologist Catherine Ramsland. And we will have an in-person crime time event on Sunday, April 8th at the Pleasant Pheasant in Woodland. On Saturday, April 18th, Clay Stafford from Killer Nashville will be our guest speaker. And that gets us up to April. That's pretty good. Let me ask you now to please mute your audio and turn off your video during the presentation. It saves bandwidth and it reduces the background noise. Also, if you missed something, we are recording Terry's presentation and it will be on our YouTube channel in about a week. With that, let me introduce our esteemed guest, attorney and author Terry Dwyer. Terry retired from a 22-year career with the New York State Police and is now a professor and attorney teaching legal studies at Western Connecticut State University. He is also author and a playwright. He wrote 3 textbooks, the most recent being Homeland Security Law, Issues and Analysis, and he is a featured columnist for police1.com. His new play, Depositions, premiered in Scranton, Pennsylvania, and his new book, The Badge Between Us, was recently published. With that, welcome to Capital Crimes, Terry.
Thank you very much, Rick. And thank you for having me. Karen, I met at Las Vegas at the Public Safety Writers Association, and I was pleased to get this invite via email. And so here we are. So glad to see everybody, meet everybody, and looks like you got some good numbers. There are 4 main areas I'm going to cover. I didn't realize you wanted stuff about setting up a independent publishing company, but I can talk a little bit about that. But basically, I'm going to start with some fair use, some basic copyright information, and then AI, legal issues involving AI, and that's just developing. So and then finish it off with estate planning for authors. I also have a list of questions, several questions that were sent in to me that I'll cover at the end, and we can also have any other questions at the end. So I'm just going to share my screen now, and hopefully, once again, it'll work. And let's see. Okay. So, all right. Can you see everything? All right. So, yeah, fair use. Let's talk about that just to begin with. I think a lot of people have a bit of a misnomer about it and get into trouble when they make assumptions about what fair use is. And also, I think sometimes people confuse it with information in the public domain. So, fair use is just a limited use of copyrighted material, either with or without the original creator's permission. If you're going to use extensive material that's previously created, obviously you need to get the author's permission. But the law does allow a limited use depending upon certain criteria that the courts have laid out. Acceptable uses are parody. Think Weird Al Yankovic and all the songs that he did over the years. Commentary, criticism, research, anything for teaching, scholarship, and quotation, provided that it's a limited use of quotation. And essentially, what the law looks to do with fair use is balance the right of the creator, the individual who owns the copyright, with public access to the information and public use to the information, again, within a reasonable realm. So this is a four-factor test that the courts use, both the federal and the state courts, if they have fair use litigation in front of them. It's codified in Title 17 of the United States Code in Section 107, and then there's separate case law regarding it. But they look at the purpose and character of the use. Again, does it come under any of those permissible categories? Parody, criticism, commentary. The nature of the work that is copyrighted. Is it a photograph? Is it a audio recording, music? Is it a poem? Is it something from a scholarly work? Is it something from a novel, nonfiction? The amount and substantiality of the use. You are entitled within limits to use, let's say, I'll give you an example, song lyrics, and provided you don't use the whole song. There's usually a percentage that the courts will look at if it's a small percentage of the whole. So like if there's 12 lyrical lines in a song and you use six of them, that's not going to be fair use. If you use one line, two lines, and you're using it as a quotation, you're fine. And then the effect on the potential market. How does it impact the rights of the original author? Is it going to have a negative impact upon their ability to sell copies of their work? And the courts will look at each one of these tests individually. So they might find no as to three of them, but then say, well, it has an impact though on the potential market of the work. So it's not that all four have to be met. How do you avoid the potential legal issues? Well, you can provide attribution, right? That's the easiest, that you don't take any credit for it being yours. This is work of somebody else's. You're merely quoting it. But that's not a guarantee. And a lot of people assume, like, well, as long as I give attribution, I'm fine. That's not the case. Use only what is needed. So, for instance, my book that just came out, there's a scene in the book where my partner and I on the midnight arrest an individual who nearly hit us on the interstate along with the drunk driver we pulled over. And he was going the wrong way on the northbound lane of the interstate. So we get him a mile down the road after chasing him, and he has no idea what happened. Turns out he was coming from a gig where he was the lead singer of a band. So later in the car, he's oblivious to everything that's going on, and he's singing Rose Tint My World from the Rocky Horror Picture Show. So, I put that in the book. Now, Rose Tint My World is 91 lines in it. I use 3 lines, maybe 3.5 lines, and they're used as a quotation. And I talked to the publisher about it, and the publisher says our standard is, 3 to 4 lines, you're good to go. So like that's all I needed to use it. Obviously, if I used anything more, if I got into 10 lines, if I got into 20 lines, and again, depending upon how it was used, it could be a problem. And again, give it context. I'm writing this. It's a statement. It's a factual statement of what the person was doing. They happen to be singing these lyrics. And then I referenced that they segued into singing Monster Mash after that. And I obviously didn't use the lyrics there, but just gives you an example of what is fair use versus where you get into problems. If you're citing, let's say, a paragraph of text from a novel, you're going to have problems. You're not going to meet the four-factor test. And I'll talk a little bit more about this in a slide or two when I talk about public domain. By the way, I did send these slides over to Karen, so they will be available when Rick, you make this presentation available. Anybody can have the slides. So here's the thing with fair use. It's a legal defense. It is not a right. It is your defense if you get brought into court for litigation. And I actually just had a scenario this week. It involved a photo that was supposedly taken by the Associated Press. And there's a third party that a lot of these groups use to collect fees for copyright infringements. It's like a precursor to a lawsuit. Basically, hey, you've used this copyrighted material. Here's what our client feels it's worth. Pay up or we're going to institute litigation. So in this case, the group had used a photograph, an Associated Press photograph in a newsletter, an in-house newsletter that went only to the members of a group, very much like yourselves, a not not for profit or not a corporation or any entity that's looking to make money, and that wasn't a defense, and fair use wasn't a defense either because again it's a copyrighted photo. So the path of least resistance was to pay the $250 fee. Mea culpa, we won't do it again, and it was taken down. It had been down from their site, and anyway, but this third-party group, on behalf of the Associated Press, had kept track of the use, how long it was up on their website. So there are people out there, and there are entities that look at what material is being used. Now, this is just a photograph, but again, the music industry is very protective of their clients and their copyrights. And again, same thing, and any author can find their material online if they search long enough. I know I've certainly found some of my articles from Police One that have been reposted without permission from Police One, and I've sent out a few emails, or I've contacted my editor, and they've sent out emails. And not that it's an issue. They give attribution, but you should get permissions. So fair use versus public domain. Uh, and this is where again people get somewhat confused. Fair use, we're dealing with copyrighted material. Public domain, the copyright is expired, or it's something like a statute that is in the public domain. Owned by the author versus owned by the public. Once it's in the public domain, it's free access. So you might be familiar with websites like Gutenberg Press, and they'll have old books on there, books written in the 19th century or 20th century books where the copyright has expired. So rather than buy it, you can download it. Again, fair use is not legally guaranteed. Public domain you can use without restriction, and also you can use it, you can adapt it, modify it, and publish it. Now, I have to just tell you a quick story. My last textbook, I got into an issue with my publisher about public domain and fair use, a public domain fair use argument. And I had a permissions editor publisher uses to go make sure anything that's not the author's, like charts and graphs and whatever, that you have appropriate permissions. And uh, my last book was a textbook. It's a legal book. I have a lot of U.S. Supreme Court citations there. And this permissions editor wanted like certain attributions and certain marks in the book and wanted permissions. And it got to the point where I had to contact the publisher and speak with the publisher who brought me in for this book and say, look, they don't know what they're talking about. I had a, 2-page email of case law and everything else to make my point. And I finally exploded and said, look, I bet this is a 20-something right out of college, has no idea of the legal difference between the two, and is really just covering their rear end. And my publisher came back and said, yeah, exactly. They're 26 years old, and this is their first, go around at this. And I said it's public domain, U.S. Supreme Court decisions, case law, statutes, they're public domain. We're not going to go down through the hundreds of cases I've used and put in these things. And this is a book that had over 1,400 footnotes. So, that would have just added to all of that. But again, sometimes when you're dealing with the publisher, you're not always going to be getting people that are attuned to these issues, and you might get somebody, like I said, right out of college or work their way up as an intern, and now they've got this position, and they're being a little bit extra careful, which I don't mind. But this is there's set law on these things. So again, if you're going to use something, obviously give attribution, but limit what you're going to use. The best defense, though, is always to ask what they say, ask permission rather than for forgiveness. If you think you're in an area where you want to use something and you're not sure if it's going to violate fair use, you can always contact the owner of the copyright. Public domain, have at it. Copyright law, and this is going to kind of segue into what I'm going to talk about later with not only AI, but also with estate planning. With copyright, you're talking about one of four basic intellectual property rights. With your copyright, your trademark, your patent, and your trade secrets. Copyright is the only one that really applies to authors, but I put a little asterisk there. Trademark can apply as well. If you have something that is branded, you can trademark that. So think of, authors like J.K. Rowling. Think of even, I would say maybe even Stephen King. They have certain, and definitely Rowling has definitely a trademark on that whole franchise. So if you're a writer and you have a series or of books, mysteries, uh, what have you, you should consider down the line if it gets popular and you have like a certain character or you have a catchphrase or whatever. Think about trademarking that as well to protect it on top of your copyright. Again, Title 17, United States Code, sections 1 through 8 and 12. Uh, you'll find the U.S. Federal Copyright Statute. There is no international copyright. That is not like in the United States where we have the Copyright Office. There's nothing under international law. What it is guided by is a set of different treaties. These are the four main treaties or conventions. The Berne Convention, going back to the 19th century, Universal Copyright Convention, the TRIPS Agreement, and the WIPO Agreement. These are either through the United Nations. I think the Universal Copyright Convention is through the United Nations. The World Trade Organization is the TRIPS agreement, and the WIPO agreement maybe as well. Basically, all they do is set the guidelines for member countries, and the majority of existing countries, nations are part of these conventions or these treaties. And it's to guide the rights of authors, photographers, musicians, any sort of artistic rights. They protect the ownership, they protect the copyright, they protect the aftermarket sale. There are international forums where, if there was a copyright infringement, your publisher could obviously wade into. If you're an independent, it's a bigger uphill climb. Obviously, litigation in general is an uphill climb. But again, there's nothing like there is at the federal level here in the States, and that is, with the filing of your copyright. Now, what does the copyright provide? I'm sure you're all familiar, and maybe in the early phases of your work, you did that little C, right? That little copyright, all rights reserved, have your name and the year, and that's good. That's a common law copyright. It protects all unpublished work. What the copyright gives you is the exclusive right. You can reproduce it, adapt it, distribute it, perform it, or display it. The statutory lifespan is the life of the author plus 70 years. After that, it goes into the public domain unless there's a literary estate, and the literary estate can renew. I believe they can renew the copyright. They can renew the copyright. Um, when you do the little squiggly, the little C copyright symbol, your protection vests automatically. You have copyrighted protection under the common law, but registration really is what benefits you in lawsuit. If it's going to be published, obviously you want to file your copyright and get your copyright. If you're going through a publisher, the publisher is going to do that. If you're publishing independently, you're filing your copyright. But that is really the teeth, the legal teeth that you have should somebody infringe upon your copyright. A statutory copyright, and I know over the years I've read about, I've talked with people in the past. you know, I save money, I put it in my book, I self-published, I put it out into the world, I did my own copyright, common law copyright, and then they schooled me in the law on common law copyright. Well, everybody's got their version of the law, but it's not the right version necessarily. So, common law copyright or is not going to protect you to the extent that a federal one will, and I'll talk about that in a moment. Expression is protected, your words are protected, ideas are not protected, titles are not protected. Um, and that too, when we talk about, what can we copyright? Well, you can't copyright an idea. Or if you see another book, wow, that was a great title. I mean, how many of you have looked at titles, right? And you want to name your book, but you want to make sure there's not another title out there, right? Well, even if there is, titles aren't copyrightable. Lots of times, if I see people, and sometimes there might be three similar titles, but then they'll have a subtitle which kind of differentiates them. Uh, Obviously, ownership of the copyright in the work belongs to the creator of the work, unless you do for hire work. If you do for hire work, you are like in the status of an employee. Maybe you're hired to ghostwrite a book. Maybe you are, write articles or a journalist. Then that is the work of whoever is hiring you. They own the copyright. Now, if you're writing a book for somebody, ghostwriting it, or you're going to be a co-author, then that's an agreement. That's a separate agreement between you and that party. And there have been situations where individuals have co-written a book. They get the person who they're, maybe say it's a famous person, they'll get the marquee, name in bold, the co-author in smaller font at the bottom, but they will share in the royalties, at least to the extent that they've agreed upon. You have other situations where the book is totally ghostwritten and the person, pretty much waives their right to the copyright. They're writing it for somebody else with the understanding they're not going to have any copyright to it. They've gotten paid for their services. So common law versus statutory copyright. So common law is automatic, right? The minute you write that work, you create that work, you put that little C there, all rights reserved in your name and the year, you have automatic perpetual protection under the common law, right? Our judge-made law, our body of law that was in existence prior to different codifications of the law. But if you're going to publish, you go through the Copyright Office, you make your filing, and now you have a federally guaranteed right. When the copyright law in the United States was passed in 1976, it basically preempted every other copyright protection. So for any works done after January 1st, 1978, they really need to have federal copyright protection. Otherwise, they're not going to have any real legal defense in court if there's an infringement upon their creative product. There are some exceptions, and I'll talk about them in a moment. The common law copyright will protect your unpublished works. There are some state law protections, and there are some other claims that can be made under state law. It signifies a right of first publication versus the federal copyright, the statutory copyright, which now it's published, so it's fixed in some sort of tangible medium. So it should be filed with the Copyright Office. For instance, my play, which Rick mentioned, it was produced in Scranton in the end of September. I just had a table reading 2 weeks ago. I'm having another one in another 2 weeks. A stage reading, I should say. I am going to be filing my copyright for that play script next month, just to cover it. It's a full-length play. It's starting to get some legs, and I'm going to make my filing so that it is protected. I also have a manuscript of plays that I've written and that have been produced that I thought I was going to have a publisher for. That kind of fell through. I'm going to probably end up self-publishing at the end of the year. So I'm going to definitely copyright that manuscript, and then I may separately copyright the longer plays in that. Right now, I just have my statutory copyright, but the play is kind of in a different animal too because it's been out there. My name's been attached to it. It's a little bit different legal argument to be made there. The common law copyright, again, perpetual until the work is published. Then you should have the federal statutory copyright, which, as I mentioned earlier, is a limited term, life of the author plus 70 years. And here's the thing, proving infringement with the common law copyright is tough. As I said, federal law preempted anything prior to that. So if the work is after January 1, 1978, it should be filed. Now, there are some exceptions. There's basically three exceptions. If it's a pre-January 1, 1978 literary work, let's say, you found something sitting in a relative's, attic. They passed away. You found this manuscript. You wanted to publish it, and get it copyrighted, but somebody had taken it or stolen it, whatever. If it's a pre-January 1, 1978 work, you will have an argument under the common law, under statutory copyright. The other exception is if there is a misappropriation. Now, this is anything post 1/1/78. If there's a misappropriation of something you're working on. Say you have a hot news story, or you got the inside scoop on something, or you have data that you collected in connection with something that you're writing, and it was taken and used. Your common law copyright will that comes into an area of an exception, but it's not even a copyright defense. It becomes a matter of really a misappropriation of property, a claim under state law. But that's another exception, and the federal courts will recognize that as well. And then the other exception is if a breach of a confidential relationship. Let's say you've written this wonderful novel. It's going to be your defining work, really make it to the big time. Top five publishers is going to be clamoring for it. You give it to your agent, and your agent takes it and puts it forth as theirs. Uh, or you give it to an editor. Same thing happens. You're in an implied contractual relationship. So there's a breach of that duty that they have to you, and that your common law copyright, you could assert your common law copyright in making a claim. But those are the three exceptions. I mean, the bottom line is copyright your work, get it out there. Even if you have uncopyrighted work and you're going to start, reading it or testing the waters. And I think especially if you're an independent author and you publish it independently, you really have to protect your work, because you never know who's going to take your work and use it as their own. There are people like that out there. So if you have like a finished manuscript and you're putting it out there, and I'd even say when you enter into agreements, if you enter into editing contracts with if you have outside editors, and I don't know what kind of agreements you may enter into, but if you enter into those agreements, just be aware that to protect your rights, that even though your copyright hasn't been filed, assert in any agreement that you have that this is work that is going to be filed with the U.S. Copyright Office, that you maintain and you assert your common law copyright, and don't forfeit or let go of any rights that you would otherwise have to the work. Obviously, if you encounter a copyright infringement, you filed with the U.S. Copyright Office, you're on better legal ground, because the law provides you several protections. When you bring an infringement lawsuit, one of them is that you can get statutory damages, and the other is that you can recoup lawyers' fees under that. Also, they can impound if somebody's taking your work and publishing, let's say bootleg copies of your novel with a different cover or something. They can be impounded, they can be seized. And again, the statutory damages, and especially the attorney's fees. I mean, lawyers are not cheap, so the fact that if you're successful on your claim, and let's face it, the odds are you have a filed copyright, depending on the extent of the lawsuit and what's actually being claimed, you're on good legal ground. I mean, having the copyright is prima facie evidence of ownership. So, it pretty much stands on its face. You show up into court, here's my work, here's the work that was, the infringing, the violating text. I have a copyright. They don't, right? Or even if they do have a copyright, if their copyright is filed after yours, you're the primary there, and it shouldn't. The same works, but it could happen. Um, you're given that extra bit of legal guarantee and weight. Excuse me. Um, so here's a good segue when we talk about copyrights. and artificial intelligence. I'm not going to even ask yet who uses AI or artificial intelligence, because that would be like me going into my university classroom and asking who uses AI. I'd be better off asking who doesn't use AI to get the two hands that pop up out of the 30 students versus the rest that are using AI. Here's what I tell my students with artificial intelligence, and I've been on top of artificial intelligence since it first came out, primarily because as a university professor, we're always looking to stay ahead of the curve of the new and different ways students will try and cheat or get around their work assignments. So we used to tell students, don't use Wikipedia. We used to shake, the finger, don't use Wikipedia. It's never accurate. And students would sit there and go, oh, yeah, yeah, yeah. I was at least able to have some credence because I used to refer them to a Wikipedia page regarding a case that I worked when I was assigned to New York City. And I told them it's like a two-page Wikipedia entry. Look at it. It's wrong in four or five key areas. So I'm not just another professor telling you that. This is something I worked, and I can tell you where it's wrong. So when AI came about, I told my students now a little bit different. I used to tell them use Wikipedia as a way to find primary sources. Use it as a tool. Go and look. Some Wikipedia entries have footnotes. Go and check those footnotes. And I tell them the same now with artificial intelligence. Use it as a tool. Do not use it as a substitute. Don't use Wikipedia as a substitute for your research. And now don't use AI as a substitute for your research. It can be a beneficial tool used correctly, as we all know. But we're all human and we sometimes break into bad habits and it can be a little bit too convenient at times. And maybe we can find ourselves getting trapped by AI. But AI certainly has some negative repercussions for people in our field as writers, right? There's reduced opportunities, editing, writing, other creative jobs are being done by AI to an extent. Lower market value for writers, right? Especially entry level fields, some journalism and editorial positions, right? AI can write an op-ed piece. Um, and then if we over rely, kind of as I alluded to it before, as we over rely on artificial intelligence, it diminishes the hard skills that we've worked at. And certainly AI, as I've told my students, cannot replace human creativity. And again, it is a tool. There's also quality issues with AI. I don't know the extent that any of you, I'm sure some of you like me have dived deep into AI and played around with it. I always tell people I tested AI. I've given it some of my tests and I've never had AI get above a B minus on any of my tests. And it usually does like the C plus B minus range. And I give all law related tests. But I asked AI to write a Valentine's Day love poem for my wife a few years back. And as I tell my students, I would be divorced if I gave that poem to her. It was god awful. It was the worst thing I'd ever read. AI can be very formulaic. It looks, it uses derivative work, right? These language learning models, they're fed work and they spit back the work in a different format. It has gotten better. I will say AI has gotten a lot better. I still think that you can tell the difference between AI and non-AI writing. I certainly have been able to with students. Um, the only ones that really I think can get by are the really smart ones who really don't need to use AI, but maybe they're under a crush of different assignments and everything. The smarter students know enough to change the wording to make it seem more like their writing. Um, but the students that are just copying it and pasting it and putting it down, it's very obvious. Again, poor narrative structures you usually encounter, especially when I've toyed with it too, to write a short story for me about this, and I want to see the quality. And I then go through it, and in the past I've gone through it and I've marked it as if I was marking, let's say, a writing assignment that a student gave me, and there are multiple errors, and again, common phrases, just an overuse of common phrases, and different metaphors and stuff. And it can hallucinate, right? We've all heard about AI hallucinations. It can give us false information. It can make up its own data, and it can inaccurately cite uh, sources. I always, because I teach law courses, I always give an example to my students. There was an attorney in New York who was fined like $65,000 because he submitted a brief to court, and I think it was in Manhattan, and it had four citations that were totally made up by AI. The attorney did not check his work. And not only did he get fined, but I think he got sanctioned and disciplined by the Bar Association. And that's just an example from, the law field. But these are the different issues that we find, just as far as quality, and the replacement problem that AI brings into this field. But what are the legal issues? That is a minefield that is not going to get swept up and cleaned anytime soon. Um, First of all, if you create a novel just totally using AI, you're not going to get it copyrighted. It's because the copyrights will only go to originally created works. AI is not originally created work. The U.S. Copyright Office, when you file a copyright, requires disclosure of any artificial intelligence content. And if there is AI content, you have to disclaim it. You have to get rid of it in order to get your copyright. There was a case involving an author. She wrote a book, but there were graphics in the book that she were all AI generated. The U.S. Copyright Office granted the copyright to the written material, but not to the graphics in the book. They would not allow them to be used. Uh, AI work may, and that's may, you see it there underlined, I would say put it in capital letters, may meet copyright requirements if it is heavily edited or added to. There has to be a human element in the writing. Um, so, if you write something or if you use AI to say set up a scenario or a scene, or maybe you're stuck on something and where am I going to go next with this? You want to ask AI and they give you a scenario and like, oh, that's good. And maybe you use an element of it, but you make it your own. That's different. That's permissible. That can be copyrightable. If AI is writing it for you, no, absolutely not. Um, there have been arguments. Attorneys have tried to make, because that's what we do, tried to make some unique arguments. And there was one case where an attorney argued that um, doing the prompt, just doing the AI prompt is creative work on the part of the author. So wow, you just do an input of 5 seconds, let AI do the rest of the work, and you get credit. That was the argument trying to be made. The Copyright Office, and really you can read up on this. You can go onto the U.S. Copyright Office's website. There are manuals out there, and they released something in 2023, and they just released something in May 2025. But unequivocally, they said no, AI prompts are not creative activity. An argument was attempted also to equate using artificial intelligence with a camera operator being taking a photograph. We know that you can copyright photographs, right? Well, the photographer has to adjust for the lighting, the distance, the focus, and all that. and they take the picture, they frame the picture. The legal argument was that, well, by doing an AI prompt, you're doing the same thing. The court rejected that argument. Totally rejected that argument. But novel arguments are being put forward. So far, they're being rejected. And the U.S. Copyright Office has taken a pretty clear stance on what is acceptable and what is not. The problem, though, with AI, and here's the big problem, is the derivative nature of what may be produced from it. Uh, Again, AI is fed existing work. Unfortunately, the courts have said that's not a problem. Companies that have used, like Claude AI, that have used um, copyrighted work to train their models, their systems, and again, it's still in its infancy, and there's some conflicting opinions from the courts, but I've seen two decisions where that has not been frowned upon. But now, if you're the end user, you're using something, and you now take that from AI and you try and publish it as your own, but somebody says, "Hey, that sounds really familiar," and they start digging and they say that's my work or it's derivative of my work, you're going to find yourself with a copyright infringement lawsuit. Um, I don't know if any of you have tried this, but write me a short story in the style of Stephen King. Write me a short story, in the style of Kafka, right? AI will spit it back out at you. Not very good, not very good from my viewpoint, but it will stylistically emulate and people are going to get caught. Oh, my favorite author is Stephen King. Let me try and write like him. Let me try and write like Hemingway. And I actually did that too. Write me a short story like Ernest Hemingway. I don't know any of your opinions on Hemingway. I have my own. I'll reserve them. But this was just really horrible, 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 horrible. I don't think it would pass a high school English upper level English assignment, get a good grade. But the so the problem with and that's a separate problem which I'll discuss in a moment is the derivative nature of AI. You have to be extremely careful. And again, with AI making up something, the conference I was at where I met Karen and Julie is Public Safety Writers Association out in Las Vegas. And there was a panel about AI, and one of the panelists said, I'm not a lawyer, but I use AI for some legal stuff, and it's been great so far. And I had to tell the person, I just raised my hand. I said, be careful. AI hallucinates. They make up stuff involving legal issues, just like they'll make up stuff with other things. They don't know it gets stuck. It'll make it up. It'll invent it. So I said, you really have to verify anything you get with AI. So here's where the problem falls. Again, because it uses these language learning models and it gets fed the information. Um, is it putting something out that's substantially similar to already copyrighted work? That's going to be infringement. Does it mimic the style? Again, write a short story like Stephen King, like Hemingway, like Franz Kafka, right? Kafka is a bad example, but public domain, maybe some of his works. But again, style mimicry, that can be. King has a style. Certain authors, mystery writers have their style. Dennis Lehane, who I've read extensively in the past, has a certain style. So again, that could be an issue. And then the unauthorized reproduction. Again, since it's fed copyrighted material, it's learning off of copyrighted material how to write. What is it spitting back? Is it spitting back um, stuff that's already copyrighted, right? And you're going to be this unwitting user down the line. One caveat I would say, and I don't know, I would hope if you're using AI to maybe aid your writing, I would hope that when you do any inputs, you would disguise it. don't put in your character names. Don't put in your plot outlines. Don't put in anything that you want to keep proprietary as your own, that you eventually want to copyright, because that could be problematic down the line for all the reasons I stated. It's gonna spit it out somewhere at the end. And if you got this really great plot and you're halfway through your book and it's nobody's ever conceived of this plot before, but you're stuck on something and you want to feed an example to AI, I would really suggest just masking your characters, create new characters, create a kind of maybe different plot line, just so you're not using the same thing, but maybe will help you jar it. Because I really, once you put it there, it's out there, and um, again, you have to worry about protecting your copyright. Other issues, publisher prohibitions. If you're dealing with the publisher as opposed to self-publishing, they're going to have prohibitions about AI generated work. They do not want any. If you submit to any of the literary magazines, any of your work, or if any of you are poets, a lot of them will have disclaimers. We do not want any AI generated work. It could breach your publishing contract if you have a publishing contract and you do use AI and there's an anti-AI clause in your contract, you're going to be in breach. Again, data leakage is something just recently read about. Are there privacy disclosures if you're putting something into AI? Let's say you're writing something like nonfiction. I write, obviously, my first book is nonfiction. It's kind of memoir and true crime narrative, but the one I'm working on now is it's a true crime narrative. You know, uh, there are things, you have to be careful with what you put in. Are you disclosing private information that otherwise you don't have permission to disclose or wouldn't want to disclose, and then putting it into AI? And here's something that you should consider if and this goes whether you are self-publishing or whether you are using you have a publisher, whether it's a large publisher or smaller press. Who's doing your editing? I asked my acquisitions editor when my manuscript went to editing, and I only really learned of this post my publishing contract, but I said, who does the editing for you? Because I don't want an AI edit. And she says, no, we use live people. I says, okay, good. So no AI editing. No. Okay, that was great. She wasn't lying, but here's the other thing too. What I found during the editing and copy editing process was that even the live person, and I was dealing with a live person, does use generative AI. And many times in going through the manuscript, I saw where the AI was rewriting something that I had written. And here's an example. My colleague out there from the 10th precinct, you know how the New York City precincts go, right? The 4-2, the 4-4, the Bronx precincts. It was writing them out. So I would have 4-2 PCT or 4-2 precinct, and then the AI edit would write it 42. So I had to go back in all my edits with the person I was dealing with. Hey, no, this is getting changed. This is the way it is. Keep the vernacular. And also it was scrubbing some of the naughty language in the book. I'm writing about a 22-year police career. There's certain language in there. It was scrubbing it. Leave that in, or there was street talk, lingo. Obviously, it's not the Queen's English. It was correcting it. So I had to go back and say, now I had the live editor and they were doing the actual person, but also, and I knew this because it would show on the copies I got what was AI generated versus what they were actually going through and putting notes upon. So that I just put there for when you go and put your books out there, your manuscripts out there to be edited, ask who's doing the editing. I would never, ever, ever want AI to do 100% editing. I don't want AI to do 10% of editing. I have a suspicion that more and more publishing houses are doing it, not to the full extent, but are using it as a time-saving measure. So you might want to consider that if you're going with the publisher, putting something in your contract, or having the right to hire your own editor and have them pay for it if they go for that. But also if you're self-publishing and you have somebody that you use for editing, just make sure that they're doing the editing themselves and not AI. Because if you're not careful, you're gonna find that it's changing stuff on you. So brings me to the literary estate. What is a literary estate? Well, that is, obviously your intellectual property. That includes your author rights, such as copyrights, your moral rights, which I'll talk about in a moment, tangible property, and of course we're dealing with intangible property as well. Your digital assets, the contracts, and your royalty schedule. So moral rights are, first of all, distinguish them from a morality clause. And you might find this if you have a publisher, sign on with a publisher. There might be a morality clause, if you get arrested for some heinous offense or you do something horrific and it's made national news, they can drop you, right? You violate your morality clause, and you'll see that in some entertainment contracts. So they're in publishing contracts as well. Moral rights, though, is distinguishable from the morality clause, and they're also distinguishable from economic rights. Your economic is your royalties. The moral rights are more like a kind of an equitable protection, as we'd say in the law. Um, you can claim ownership. It gives you the right to obviously claim ownership, like a copyright, but it protects your work from any disparagement. It protects it from being used in a way that would distort the work, mutilate the work, um, change the work, and even impact your status as the author in a negative light. Not so much a protection in the U.S. to the extent that it is overseas. It came up in the Berne Convention, which was referenced early on back in the 19th century. Europe has a different view of moral rights and more protective. The U.S. Really has limited it. Some would say that they're in violation of the Berne Convention, but the U.S. has really limited it to more so performance rights, recording rights, like audiovisual art, type of rights, not so much at the literary end, but that's just a minor consideration. So here's the age-old question. When I was practicing law, which I retired from 4 years ago, as I always tell people, I'm a happy lawyer now. I don't have clients. Um, Plan an estate or don't plan an estate. Plan an estate, green light. We like that. Don't plan an estate, not so good. Um, it's always good for the lawyers because there's a mess left behind. Um, when you plan an estate, you get to pick your executor and you get to pick and choose how your property is distributed. If you don't plan an estate, state law determines who administers your estate and how your property is going to be distributed. The choice is taken away from you. And there's usually each state has a different statutory schedule as far as how property gets distributed. So obviously there's benefits, and also it's more costly not to plan your estate. It's more costly down the line for those left behind. Because there are many things you can do when you're planning an estate, such as a trust, that can really streamline the process. People, probate gets a bad name. And probate is when you go into court to prove a will. And probate really isn't bad at all. it's only bad if there's going to be a contest to the will. But if you don't plan an estate, it can be, the lawyers and the heirs have to track down every relative that, within a certain lineage and line. So you want to plan. Your estate is obviously your tangible and intangible assets, and amongst those are assets that are going to be subject to probate, or those that are non-probate assets that they pass by operational law, like if you have a life insurance policy with the beneficiary, right? Your literary estate is part of your estate, but it's a special, it's different type of property we're talking about. We're not talking about giving away clothing or jewelry or artwork or real property, personal property, cash. We're talking about the intangible intellectual property and then the tangible property, what manuscripts and journals you may have. So if you are a writer and you have several works that are out there and you've made some money off of it, you know, create a literary estate. And you may think like, really, I'm not, what's it going to matter? Well, you never know. And I'll give you an example in a moment. So inventory your assets, inventory all your intellectual property. And that includes the published and the unpublished works in progress, right? And those manuscripts, those hard copies of your journals. Hold on to them, have them inventory so your executor knows, and then choose a literary executor. Now, do you have to have a separate literary executor? No, they can be the same, they can be the executor. However, your executor might be the person who you trust, who's really good with money and managing all that, but they don't have a clue about uh, the arts. So you can designate a separate literary executor, but you don't have to. So the literary executor is going to act as per your instructions that you place in the will. How are your copyrights to be handled? How's your intellectual property to be dealt with? They can sign contracts for you if there's reprints, any payments, right? Payments, so royalties will still come in. Transfer the monies to wherever you want it to go. You have to check your state law though. Make sure every state has a probate code. So you would best to check with an attorney in your area. The literary estate, well, have their size and value, will or trust. If you have a big literary estate, you're talking, tens of thousands of dollars. Let's just start at that threshold. Um, you want to consider a trust. A trust is a mechanism that operates outside of probate. There's no court filing. You designate a trustee, and there's a lot of benefits. I'm sure many of you are familiar with trusts. You may have trusts, so you may want to consider that. But here's the other thing too. You might be sitting there saying, "Well, I'm just, make a few extra bucks each year, a couple of thousand. I have a little bit of a following, but you know." It's really not going to amount to much. Well, I'll give you this example. Um, what may not be worth anything today may be worth millions tomorrow. There was an author named Fletcher Nebel who wrote in the 1950s, 60s, I think into the 70s. And he was, he fed his family through his writing. He was, a kind of just basically, middle of the road, plodding writer, had books out there, made a living, and had a bit of a following. But he wrote a book, Night of Camp David, and the book dealt with a president who um, was very fond of Russia and the Russian leader. It had a U.S. Supreme Court justice by happenstance to the name of Kavanaugh. All of a sudden, this book flew off the shelves during the first Trump presidency. I was in Grand Central Station in Manhattan, getting ready to take a train back north home, and I saw that book and I grabbed it because I had heard about it on the radio. They had easily 100 copies of that book. I read it, quick, easy read. It was funny how really close to just like circumstances in the first administration and things that were going on. And it was talking about the 25th Amendment. It was uncanny, referencing 25th Amendment. It was uncanny. Uh, that made millions of dollars. You can imagine this family, Neville's family, sitting there getting their maybe, $50 residual checks every year. All of a sudden, they're getting six-figure checks that are just flooding in. But another author I'll mention, if you are any fans of Philip K. Dick, who wrote The Man in the High Castle. He won, I think, a Hugo Award for that. That was his only win. He was very prolific. He wrote like 45 novels, short stories, everything. He died at 53, complications of a stroke back in 82. Since that time, Man in the High Castle has been a Netflix series. One of his books was the basis for Blade Runner. The only really royalties he saw, he really lived impoverished life until like towards the end, just before he died, when he was starting to get some Blade Runner residuals. But his estate is worth millions upon millions of dollars now. And his daughters, I believe he only had two daughters, created a trust. A trust was set up, and they manage his estate now. And they're very protective of his estate because some of his work, um, there were claims that it went into the public domain, which it didn't. But they fought that, and they kept the rights. So, here's an example of a guy who, he had a little cult following when he was alive. His work didn't amount to much. The Man in the High Castle was his really first and only big award. Kind of had his following, but then really just hit it off posthumously after he died. And that's a very substantial literary estate right now. So, never say never for your work. You may not get to see to enjoy it, but generations after you might. So again, inventory your intellectual property, document all your published works, your contracts, any pending contracts and works that you have out there, and your digital assets. And somebody had a question about digital assets, or there was a question, and I'll circle back to that when I'm done with this. And that includes your websites and social media. Again, your unfinished works, what's to be done with them? We're always hearing, that unfinished, F. Scott Fitzgerald novel, or this author, their unfinished work, and now it's being published. Again, sure, your heirs can access your computers, your passwords. You might want to have a manager, for that. Your platforms, do you do Kindle, direct publishing? Are you on Ingram Spark? Again, your copyright, you can say in your will or your trust, um, give directions for how your copyright is to be managed, any licensing issues, any restrictions on its usage, and then draft an instruction letter. Um, Now, your will and your trust, those are the legal documents. Instruction letters are just that. They're separate letters that go to your fiduciary, your executor, with directions of what you want. State law varies, but I'm admitted in New York and Connecticut, and instruction letters are not part of the state, but they are a guideline. Once the executor is appointed, I have this instruction letter. I'm going to follow that what the deceased wanted. And again, just consider more than your published works. We all have, I mean, I have notebooks. I'm sure you all have notebooks, if you still do it old school style, save files, floppy disks, if I go back and date myself, zip drives, right? You want to hold on to all of that. Any ideas you might have for future projects, any outlines. All of your correspondence too. If you're dealing with a publisher, if you're dealing with an agent, if you're dealing with editors, your personal journals. Maybe you're the writer that's discovered in death, right? You want those journals are going to be valuable as far as your estate goes if you become a popular writer. I was researching Philip Dick earlier because his stories just always intrigued me. And then there's a publication of some of his unpublished writings. And again, any trademarks, right? J.K. Rowling, you can imagine what her literary estate is going to look like. And she not only has the copyrights, but she has several uh, trademarks there. Her characters, are there catchphrases? Are there worlds that are created? Are there games like Quidditch? These things are invented. They come from the imagination, and they are all part of your intellectual property and your literary estate. And it's very easy to create a literary estate, just like it's very easy to create an estate. If you don't have an estate plan, I would encourage it, just as a public service message. Uh, but you and that's all an estate is inventorying your property. You would have a separate section in your will or your trust document that deals with the literary estate or your literary property. And it's as simple as that. But you should have a professional to do so. Don't do any self-help on the internet because that usually creates problems, and you end up going to see an attorney anyway to undo the mess. That's it for now. There's my contact info. But I want to get to the questions that you all had. Um, and before I do that, is it okay if I get rid of the
Oh yeah,
PowerPoint?
get rid of the slides. Yeah,
Yep.
and
Okay,
again, I
great.
will be sending them out to all registered attendees,
Yeah, yeah,
anyone who
please.
registered.
Yeah, yeah, yeah. Please do. Okay, so stop the share, and I am back. So, the questions. I love your questions that I got ahead of time. So, how are digital rights handled in a state? That was the first question, and that segues right into, my ending. There is a law. Not each state has separately codified it, but there's a thing called the Revised Uniform Fiduciary Access to Digital Assets Act, also known as RFUADAA. Basically, it's a guideline, like the model penal code, and states can use it to draft their own penal codes. So states have used this to draft their own sort of digital rights legislation. California has such an act. Connecticut, New York, Oregon. I mean, different states do, or they're in some different formation. I think California's goes back to 2017. But again, you need, those. We're in a different world than we were 40 years ago, even 20 years ago. Those digital assets, everybody has a big digital presence that might be part of that literary estate too, to keep your Facebook page alive, to keep your social media alive. So you're going to want to give that to somebody, and you're going to want to have kind of a fiduciary or a manager. You could have a digital rights manager. So you could have essentially a digital rights manager, a literary executor, and an executor for your other personal property if you're setting up a literary estate. And again, it depends on what you want to do, how you want to manage that. We're considering, so this is the capital crimes, nonprofit status for capital crimes. What type of nonprofit would be best? What are the advantages and disadvantages of nonprofit status for writing chapters such as ours? Well, you won't have the bank shut down your account, Rick, like they did the last time. That'll make it easier. Well, you're going to get tax exempt status. If you're going to become a 501c3 corporation, you have to set it up as such. It's setting up a corporation is real easy. Setting up an LLC is real easy under the different state laws. I've only done it in New York. But I'm familiar with Connecticut's as well. However, with that being said, a 501c3 not-for-profit has several more hoops that you have to go through. You need to have an attorney that's familiar with not-for-profits, that's familiar with setting up a 501c3, and that's familiar with the IRS regulations. It's not onerous, it's just a little bit more time intensive than normal. What you can do as a non-for-profit now, the 501c3, you can apply for grants, you can apply for donations. That's certainly a benefit that you will have. You have limited liability, which I mean, you say, well, we don't have anything to worry about liability wise, but again, you never know. So you do have that protection. Again, the key disadvantages, I have some notes here. Just the regulatory requirements. I mean, really, to keep up with the 501(c)(3) filings to make sure, your finances and everything are in check. But other than that, there's really, no disadvantage to giving you that corporate protection. You're gonna have to have a board. You're gonna have to maybe be more formalized than you. I'm not saying you're not formalized now, but you're gonna have that extra layer of formality. We have to have certain meeting. We have to have a board of directors, or a board of managers if you're a limited liability company, and just kind of proceed along that line. But not a bad idea, especially if you're a larger organization or growing as you would have.
Terry,
Um, yeah,
before we continue, I just want to
sure.
make sure everybody knows we'll get to the chat questions as soon as you
Yes.
address these earlier questions.
Yeah, please. And I see, and hopefully I can answer the chat. I see there's a bunch of different things in the chat. So can a writer deduct? And any tax questions, I'm just going to give you the disclaimer that I am not a tax guy. That's why God invented accountants and I hire an accountant. But some basic tax stuff I can answer. And these questions here. Can a writer deduct the cost of writing classes and webinars, writers, conferences, and travel-related researching a new book as business expenses? And if so, are they deductible only if the author had income from writing activities in the same year that those expenses were incurred? Answer to the first part, yes, that goes on a Schedule C when you file. Last year was the first year that in my taxes that I claimed deductions as a writer. Um, so I had income to show as a writer, and like in the past, whatever writing income I have, because I was doing legal articles, I put them in my law expenses, law income. But um, now, last year, and then this year is going to be my second year filing separately as a writer slash consultant. So I have that in there, and then I have my deductions. There's people think, oh, I have to show a profit after 2 years, 3 years. No, you don't. You can still take those deductions. However, if you're in your eighth year and you're still not showing a profit, yeah, it's going to be a hobby. And then you're not entitled to those deductions. So what I, tell people is, especially when dealing with the IRS, don't be greedy. If you're in year four, don't have, $50,000 of expenses versus $5,000 of income. You're going to get audited. You're going to get, have a knock on the door from the IRS. And then again, you can, take your, I take travel expenses. I, take expenses if I buy a book, library, within reason. I don't get greedy, but oh, this is related to what I'm doing or to my writing. Your lodging, your meals, your research, software, you need a new computer. Again, like anything with the IRS, within reason, don't get greedy. But there's no like hard and fast rule the second, third year. But there is a point in time where you're just gonna have to say, look, this is a hobby because I'm spending way more on this than I'm making. So, and that's a discussion for you and your accountant to have. If you change the name of a business in a story to give it a wink and a nudge, sort of an homage, is that okay in legal sense? For example, if I were to change Five Guys, my favorite place for burger, love that, to Go Nin, literally Five Guys in Japanese, in my fictional superhero Metropolis, and have a protagonist eat an awesome burger there, could this get me in hot water? No, it won't get you in hot water. No, broadly, yeah, you can do that. Absolutely. But make sure the made up name is not the name of a real company somewhere else. So make sure that Go Nin is not a company somewhere in the US. And and you can use real names as well. I mean, my book, I have real names. I mean, they're in a linking navigator, or whatever you're going to use. That's life. It's a factual statement. The only thing you really have to be worried about is not defaming the company or the product. That's essentially what it comes down to. As long as you're not defaming the company or the product, you will be fine. Um, If a sleuth solves, if a, excuse me, if a sleuth solves a cold case, not a murder, in the course of solving the murder mystery, and the murder and the cold case are connected, would the ability to prosecute the cold case along with the murder depend on the type of crime or statute of limitations for the cold case, or would the fact that the cases are connected allow the cold case to tag along? Well, I'd love to read some of these stories because these questions are great. So I wrote down here in my notes, like, give me an example. I really have to know an example, but using my imagination and also just really an answer to the question, it really depends. There's no statute of limitations on murder. There are statute of limitations on other crimes. But again, statute of limitations provisions are state specific. Statute of limitations can be told, as we say in a legal sense, basically paused under certain circumstances. In this instance, if you have a 30, and here's the example I wrote down. If you have a 30-year-old murder case that is solved and you can prove a lost or stolen gun was a murder weapon, and you find the gun, and you find that the gun is connected to the murder, you can use the gun as evidence of the murder, but you cannot charge for possession of the weapon because that would be precluded by the statute of limitations, even though the murder would be within the statute of limitations. Now, there might be exceptions under state statutes dealing with felony murder, and every state has a little bit different variation on the felony murder rule. But other than that, you would be time barred. And I hope that answers it. If not, give me a little bit more specific scenario.
Terry, I think it's from Dover, and
Mhm.
she's saying the cold case is child endangerment and disappearance, but kid is found 40 years later as an adult.
So the case is child endangerment. The kid is found 40 years later as an adult and asking if the parents can be charged with child endangerment. Is that essentially it?
Dover, do you want to speak up?
Yes, that is it, except it's not the
Oh,
parents, it's the teenagers that took him to the dangerous place.
gotcha. Well, so that's a really great question. That's a really great scenario. No. So it depends. So here's the thing. So, for certain crimes, and just let me just go like to the Catholic Church and, the molestation of altar boys, right? Or certain sex crimes, look at the Epstein case, right? These all would normally be time barred, but the law does have certain provisions for certain types of crimes, and there's a matter of discovery, right? From the time of discovery, and then you have X number of years. If you're working within a specific state, I would say go to the state statute, look up in the criminal law the statute of limitations, and look up tolling provisions. But I would say no. If you're dealing with a functioning 42-year-old adult, teenagers took him at one point in time and did whatever, but he's grown to an adulthood. That's a statute. That'd be time barred. As an attorney, I'd be making that argument, and it would likely be successful. So no. I like to set the right stories set historically, so there are maybe occasions where I want to include a real person in my stories. How does an author navigate protecting themselves if using real persons or businesses? I don't necessarily mean a negative way versus the advice to not use real persons, witnesses, especially when writing historical. It's fun to utilize at least a few real people or businesses to set the flavor of that historic time. Yeah, I mean, names, first of all, are not copyrighted. The older historical, if they're long gone and dead, have at it. Not an issue. You only have to worry about somebody if they're more recently dead. And you also have to worry about right of publicity. So in my book that just came out, I changed certain names. There's a gang case that I worked. I changed the names of all the gang members because to give them that degree of anonymity, because some of them are out leading productive lives now, out of prison and whatnot. There were other names that I used. Elliot Spitzer, the former governor of New York, who prosecuted our cases when I was down in Manhattan, is mentioned in my book. Nothing in there that's negative about him. Just he was a brilliant lawyer. And John F. Kennedy Jr., who was an attorney in our unit, I mentioned too. There's a scene at a party And again, nothing negative, but mentioned in there. So and then there were some actual names that I used, like anybody on my job I made up. But then there were some actual names of people who were arrested, and that's public record. So, that's just as a guideline. So yeah, you can use public names, historical names. You just have to be careful when you're using if you're using a public figure, a political person, usually you're on safe ground. If you're using a private person in their real name, you have to worry also because are you violating, and some states will have like a right of privacy protection. And an argument can be made you're using it for commercial gain. So I'd be careful with that. And then if you're using a person, say a historical figure, now let's take Marilyn Monroe, right? So she's modern enough, but we can call it historical too. There's an estate, right? She's got an estate. Marilyn Monroe. I used to teach her will when I did wills, trusts, and estates as a course. I used to use her will, and she's worth way more now than what she left behind when she died. So you'd have to be careful because there's still a right of publicity that Marilyn has. So that would be a warning. But if you're talking about 1800, 1700, something like that, you're not going to have any issue. This may be better served by asking accountants, but since it sounds like you will discuss an author business, other ramifications if your LLC doesn't show profit. I think I kind of answered that before. If your LLC doesn't have profit within 2 years as you designate it as a hobby. And like I said, no, there's no hard and fast rule. Talk with your accountant about that. But again, don't be greedy. If you're going into that fifth year and you're not making it, but you're showing like really way, your expenditures are so far above your income. That's just going to be a red flag, especially if it's not within the first 2 years. First 2 or 3 years, they expect it. After that, you're going to get a little bit of a leeway, a grace period, but then they're going to look and see and just say, this is a hobby. You can't write that off. Let's see here. I sold all my books through Amazon and under the auspices of the CW branch anthologies. Don't know what that is, but I know I have to pay my income tax, but I do not have to fill out the state sales tax. But do I have to fill out the state sales tax form I keep getting emails about? If the state is sending you emails, it's never good to disobey the email, not answer the emails. They will not go away. Usually if you're selling, if it sounds like here you're selling through like KDP or something like that, Amazon acts as the salesperson, the retailer. They're collecting all the taxes and doing all that, and they file forms. But income tax and sales tax are two different, two different things. So I know it can be bothersome. There is an intersection, between sales tax and income taxes, but this is sales tax is a consumption tax, and the state has a right to gather that, and each state has its forms. I know New York has a whole ream of forms for sales taxes. So you might be in a situation where they want you to fill out the form and you're basically saying, I don't owe anything. Just fill out the form because Amazon's already taken care of it, because it's better to comply than have them coming and you may be getting fined for something you didn't do it was easy to do. But again, I would take that up with your accountant. Generally, I don't think you would have any sales tax liability since Amazon took care of that, if I'm understanding the question. But yeah, don't ignore the form. If they keep emailing you, they're not going to go away, and there's something in their paperwork that has to be satisfied. And is that it? No, I think that was the last of the questions. I think I hit them all that
Great.
were pre.
Okay, thank you for that. And gosh, let's hope that we can get through these in the chat. The first one is, as an independent publisher, are you eligible to submit your author's books to the big award competitions and to the major review platforms? Is there a number of authors to reach critical mass?
Boy, that's a great question. When you find the answer, let me know. I don't know. It's funny because I'm just looking at some contests to enter my book in. So my publisher, I asked my publisher about this before, when I first started. They will not send. They don't do that. They don't. Then Bloomsbury's my publisher, and they don't do that. But certainly, if there's some that I highlight and they think it's worthy, they would do and they would file it. So I'm on my own on that. So I don't think so. First of all, for independent or self-published works, there are separate awards and contests that you can enter. But I don't know. I can't give you a wholesale answer because every contest is different. You really have to look at the contests. I don't think that there would be. And what I'm seeing in some of the contests, they actually have separate categories for self-published. I think the Pen Awards might. I was looking at something recently, and I'm like, oh wow, they have a self-publishing category now, which I saw. So you're really gonna have to look at each independent site and see because they're gonna give you your specific guidelines. Some don't take nonfiction books. So I'm like, I can't submit here because they don't do nonfiction books. So it really gonna matter, but it's really gonna depend. But I don't think just you're foreclosed. No, I wouldn't say wholesale. You're foreclosed. Just look at each one separately.
Julie asked, and some of this you've already addressed, but her first question you didn't. I'm writing a police procedural novel. Can I use the agency name? And then she asks, similarly, can I use brand, business name, Starbucks, Coke, Chevrolet, etc.?
Yeah, so when it's a great question, Julie, because I originally in doing my cover for my book, I was going to use the shield, my shield, and then I not to because I did some research and I'm like, oh wow, they got a trademark on that, so I can't use it, right? You run afoul of that. I did use my job name because yeah, I work for them. I'm an employee, sure. Yeah, I'm not going to make up who I work for. Gotham PD or anything like that. So you could use your agency. I don't see a problem with that. I would not use anything in the cover about, your insignia, your uniform, or anything like that, unless it's like you in uniform. And I know you're writing fiction, so it probably doesn't apply. But I wouldn't use like the actual agency on the cover. But yeah, and then as you using the brands, as long as I have, like I said, in my book, I have Lincoln Navigator, Chevy Caprice, Tahoe, whatever. These are just there. They're out in the world. So as long as you're not defaming the brand or doing anything to negatively impact them. It's funny for my publisher, I had to fill out, when the book manuscript was in, it was in the editing process, you do the author's questionnaire and then they have one on your book and like all the brands named in your book. Well, going through it, Cold Stone Creamery's in the book because my wife sometimes when we got stressed, all right, let's go out, ice cream dinner, and we take the kids out to Cold Stone. I'm hoping maybe they hit me up for an ad someday. But so yeah, you can use those, or you can make it up. But if you're going to disparage a brand, I would say make up a name and make it as remote from that brand as you can. But yeah, we're in a world we drink Starbucks coffee and have a Coca-Cola or whatever. So
Okay, and the next question you addressed, it was about song lyrics. And the next question is, some of the members of our chapter want to write an anthology containing stories about a famous singer. Is that allowed? Fan fiction, not sure if they want to use lyrics.
fan fiction about a living singer or dead?
Oh, they did not specify. I'm not sure if
It
Linda, yes, go ahead.
actually the chapter wants to write an anthology about Bruce Springsteen. So some of them are writing fictional stories about Bruce Springsteen. I don't know if some of them are using his songs as inspiration, but can we just put out I kind of am a little nervous saying that, you could just write all stories about Bruce Springsteen. And plus I kind of said there's also a political slant here in different ways without getting into politics, you know what I mean? So I kind of was thinking this was not a good project, but I was just wondering, can you just write whatever you want about a famous live singer? And in terms.
Interesting. So, I wrote a short play and Bruce Springsteen's name was in there, but just his name. Um, so if there's once again, if there's going to be anything disparaging, anything potentially defamatory, anything to hurt his image, you're going to have a problem. I think you would really need to contact Springsteen's people and get the endorsement.
Thank
That,
you.
that would be like if I was the attorney advising, that I would say, you know, to be on the safe side, because Springsteen's got a lot of money, got a
Yeah.
lot of lawyers, ask permission, first rather than forgiveness later. So I would look to contact his publicist. And Springsteen may love it. That he's the type of artist where depending upon the work and what you're doing, again, if it was, favorable, he might love it and give it a green light. And boy, how great would that be? And you have a little forward by him.
Oh, that would be great. Yes.
Yeah, but that would be my suggestion. And it's funny you bring that up because I had a friend of mine. I went through an MFA program, so I got my MFA last year. And I had a buddy in there who was in the screenwriting, doing screenwriting, and he wrote a script that dealt with Stephen King's work. And he had a really good mentor, and he said, this is really good. Here's a problem you're going to run up against, but you know what? I've got a contact. Let's try and get King's permission. That solves everything. Because otherwise he had a big hurdle to get over. So I use that as the same guideline, get the permission. Sounds like a great idea. Just get the blessing, so to speak, and then, let him vet whatever's being written.
Thank you.
Yeah.
The next question is, what if I have a series that starts to get popular and somebody trademarks it before I do? Is that a possible?
Yeah, beat them to the trademark office. You mean copyrighted or trademark? You already have a copyright, but now you're saying like you got like J.K. Rowling and like, I have to trademark some of these things like catchphrases or certain.
Laura, are you here that you could clarify? She may have left.
Yes, she's there. I just saw her pop up. So I just see a yes from Laura. I don't know if.
Yes.
Trademark. Okay, trademark. Okay, I got it. Yeah. Yeah, look, it's so easy to kind of do the filings in a sense that if you think it's a good idea and you're worried about it, just do it. Pay the filing fee and do it if you got something that you think is really, really unique. This way you're protected. But yeah, sure. Could somebody what was that story? And I don't know how true it was, but I thought it was true. Right at the millennium, somebody had taken the name 21st Century Fox as 21stcenturyfox.com or something like that. Where people are trying it and people are doing .com names all the time. And they've done it for some celebrities as well, using their names to create the site, so they have to buy them out. So, I look at that as a situation. They're kind of similar, kind of a parallel scenario. If it's an idea, again, just don't forget, you can't copyright an idea. You can't copyright a title. So, without knowing a little bit more specifics, if you think that you're going to have something that's going to be popular, set up your trademarks.
Okay, thanks. And I wrote this question. I think you kind of addressed it. In your estate, would it be good advice to include instruction for heirs to renew the copyright 70 years after your death so they can continue to collect earnings if they want to do that?
Yeah, I mean that would be part. That would be part of the direction for the copyrights, that you can renew the copyright, right? So, and it just goes in the name of the literary estate. Up in New York here, we have I'm drawing a blank on her name. She's a poet. No. Edna St. Vincent Millay. Edna St. Vincent Millay, the poet from like the 1920s, 30s. She's got a place in the Hudson Valley, and she has a literary estate, and her literary estate is very protective of her work. You know, her and her husband didn't have any kids. I don't even know if she has any surviving family members, if her sisters had any kids. But there's a person, her literary executor is around, and that they are watchdog on anything to do with Edna St. Vincent Millay's work. So yeah, I would.
Okay, and then the next two questions are about using a pen name, and is that all part of the copyright and this life plus 70 years?
Yeah, I mean, pen name, you're just using, you know, that's your, I really don't know what, I mean, I know enough about pen names, but I'm sure and with the copyright, it's the same thing. You're known as, you know, what I mean, King, I use him again because my buddy was such a King fan. Was it Richard Bachman? Was that
Oh,
his?
yeah.
Yeah. So he's written several novels under that name, and the copyright, I believe, is under that name. I could clarify that. I could clarify and get back to you on that. Um, but yeah, what was the other part of the question? Didn't you
Um,
copyrighted under the name?
it was really well, one other part was, can you later transfer the copyright to your real name to get the life plus 70? So I think it's all about, when you copyright, do you use both your real name and your pseudonym, which some of
Yeah,
the readers
that
said
I don't
yes.
know. That I don't know. I'd have to double check, and I'll get back to you on that. You want to send me an email.
Okay.
But I mean, yeah, you can renew your copyright. It's just that's the lifespan of it. Certainly the estates have renewed copyrights. Can you change the copyright? That's a good question. That I don't know the answer to. You know, can he change it from Bachman to Stephen King? Would be the question. Let me double check on that, and I'll email you because I
Okay.
off the hand I don't know, and I want to give you the wrong advice on that.
The next question is, should I and can I copyright a collection of original oral stories?
Interesting question because spoken word poetry has gotten really big. It's a separate concentration at the MFA program where I went to. And they have right now a very well-known young lady who's gotten a lot of buzz. She's been on national media. She's going through the program. But spoken word stories, um, I mean, that's the original tradition, right? The original oral tradition that it all started from. I mean, it got to be written down somewhere, right? I mean, so here's my question. Are these stories that were written down that you publish orally? You go to, you go to forums and you speak? Is that what we're talking about? Or
Ivy, are you still here that you can speak up or put something in the chat?
Yes. So this is more like almost like a short story, but like an audiobook of a collection of story, but they are not published. They're published using audio. So they're orally told story. They're not like
oh, I got you.
campfire
Oh,
stories.
okay, okay,
They're
I
not
got you.
way
Okay,
back. Yeah, they're
yeah.
just
Oh,
not
okay.
in print, so to
Totally.
speak.
Okay, so you haven't put them in print. You just want to put out the audiobook of the stories.
Well, it's like a digital media. It's instead of words now it's told, but it's the same story, original, and it's recent. It's never
Okay.
published anywhere else.
Yeah. So are you the recorder? Are you the narrator?
Yes.
Okay. All right. So that makes things easier. Yes, copyrighted. But it's not going to be copyrighted as a literary work. It's going to be copyrighted as an audio recording.
Oh, so anybody could use those stories and do anything with it, even though there's
No,
original.
they're copyrighted. They're yours, but it's just an audio recording. I'm just saying you're not filing. When you file, you have to file, tangible proof of your work. So, you'd have a manuscript or something like that. You're going to be submitting a recording.
Oh, so maybe I should have AI transcribe it and file it both and say this is the direct transcript of from the recording, so I can have both. Would that be better?
Yeah, and just AI is just transcribing your words.
Well, it's just like a person. You take down
Right,
the
right, right.
word.
Yeah, that's what I'm saying. That's what we're talking about. Yeah. So yeah, yeah, absolutely. If you want to do both, you can. You can get a copyright for your work, but your work is not, it's not, you don't have a publisher. It's just going to be you. So, unless you're going to self-publish it, but your words should be protected. Your words are protected as it's a recording.
Okay, I'm just because
Let's go back to Springsteen. Let's go back to Springsteen. All right, Born to Run, right? He wrote those down as lyrics, right? But it got recorded, right?
okay.
He's got the recording. He's got a copyright on the recording. He probably has copyright on the lyrics somewhere else, right? But it's the recording that's done. So I think you would be able to when you file, and I've never done I've never done a filing for a copyright for a recording. So I don't know. I don't know if when you file, there's a transcript that goes with it. So I don't know when they file the audio, do they also like do the lyrics? That's something you'd have to check into. But yes, I would copyright it if you're doing something audio like that. You're creating an audio book or an audio file and you're putting it out there into the world. I would copyright it.
Thank you.
Yeah.
Okay, the next question. If I didn't file a copyright when I first published a book, is it worth filing years later? Also, if I make significant revisions and produce a second edition of a book, should I apply for a new copyright or does the first one still stand?
Um, Second edition, well, we're not talking now creative. We're talking about something else like a technical book.
Well, this person writes fiction, but Jessica, well, actually, she writes both nonfiction and fiction. Jessica, do you want to clarify?
Yeah, I was specifically thinking about fiction, but also nonfiction.
Yeah, so I mean, fiction there shouldn't be like a second. I've never seen a fiction like second edition. It might be a revised copy.
Right. So
Oh,
I'm thinking like I have a novella and I develop it into a novel, add
oh,
significant content.
gotcha. Yeah, I'd file a new copyright, sure.
Okay.
Yeah, yeah.
Thank
And even with the second edition, new copyrights, it's new, but it's new work, it's added work. So I know with textbooks, a new copyright gets filed.
okay.
And what they do, and if you see sometimes with books when they have reprints and everything, you'll see like the original copyright 1985, copyright 1990, copyright 1995. Those are different iterations of the copyright.
Oh, gotcha. Thanks. That's
And what
helpful.
about the first part of her question? If she didn't file a copyright when her book was published and years later wants to file, should she still do that?
So the book was published, self-published,
Yes.
and you used the common law copyright.
Yes.
Protect yourself, file a copyright.
Okay.
Yeah, because otherwise somebody come along, you know, I mean it's out there. I mean, would you have a little bit, excuse me, better arguments since you self-published and has been out there in the world, but you're not going to have the prima facie evidence should somebody use it and you have infringement issues, and it's just so much easier. Pay the fee and file the copyright, and this way it's done, it's protected, whatever, and you can say, "Phew, I made it this far without without any issues." But yeah, it's always better to get it.
Thank you.
Okay, great. The next question, if someone uses AI to research topics but do not use the AI response by writing, you own the material. I might not be reading this correctly, but do you need to disclose? So it sounds like you understand the question.
Yeah, yeah. Can you use AI for research? Absolutely, but be extremely careful. Be the expert in the stuff that you're researching, and what you're researching. See, this is where people get in trouble with AI with research. Like the individual who I saw at the conference, like, I use AI for legal stuff. It's cheaper than hiring a lawyer. It may not be because you may be misquoting the law, which I see many a time on police procedurals and courtroom stuff and everything else. Just like that would never happen. That's not reality. That's made up. That's not, they don't know what they're talking about. So I would be careful. Yeah, AI research is something totally different. But again, like with Wikipedia or anything else, go to the primary sources. Go to the original sources because use AI as a tool to lead you to more concrete sources. AI is not a primary source.
And I think she's also expressing concern about having to disclose using AI on a level like that to do some research.
I don't think, well, again, just like I said, it should never be 100% AI. You're doing a disservice if you're doing 100% AI. I personally, and I've been all over AI, I do not trust AI enough to give me the right answer. And I tell my students, I said, I can give you a specific question and you can use AI, and I know you will get it wrong every time. And that's an area in the law, you know. So it's use it again as a means to an end. Use it as a pathway to get you to other research. Use it to cut down on the amount of research you have to do. Let me give you a kind of real quick example, totally a little bit out of context, but my wife and I went out with friends on a trip to Ireland last summer. They want to do the whole island. They'd never been there. My wife and I had been there. She's been there 12, 13 times. I've been there 8 or 9 times. I put an itinerary and I did it into AI because I just didn't have time with everything else I'm doing. It did in about 10 minutes, even less, what it would have taken me an hour and a half, 2 hours to do. I was able to go through it and say, no, no, don't want to go there, don't want to there. Yep, there, because I knew Ireland. I knew where to go. AI facilitated my research by quickening it and leading me to some spots I didn't consider, and then I separately researched it, right? So just use the AI as a tool, as a pathway to get you to other things, but it doesn't, and I'm sorry, I'm talking about like an academic here, but you got to go to the primary sources, your secondary sources. It doesn't, in my mind, replace the work that you have to do in the research. It can help you get there quicker, though, and it can save you a lot of time. But I wouldn't just use 110% AI. And depending on the genre you're writing in and what you're writing about. But AI has been wrong. Just flat out, it's been wrong.
So we're getting close to the end, and so I'm just going to jump to maybe two more questions. What if I heard a stand-up comedian tell a joke and I put a similar line in my novel?
Don't let the comedian find you. I mean, the comedians, their stuff, their stand-up, they have a right to that. It's the old joke about comedians always stealing each other's routines, but maybe change it around, do something to make it your own. I'll just get quick too. In my book, there's the gang that we did. They did rap lyrics, and I used rap lyrics. It was part of the indictment. It was part of probable cause for the wire and everything else because we connected it to crimes. So the lyrics, I wanted to use an example of the lyrics, but I didn't want to use the lyrics because even though the guy who wrote them is in state prison for the rest of his life, he could still sue from New York State Prison. So I'm not even going to chance that. I made up my own lyrics. I just made up my own lyrics that, oh, here's the tone and tenor of what they would be saying. So I made up my own lyrics. Takes care of any worries about copyright. So great joke, make your own joke. And
Okay, I'll ask one more question and then Rick will want to get on here and speak to everybody. I'm curious about laws regarding LLC formation. I've seen a lot of people recommend forming LLCs in a state that has lower fees or more favorable regulations if you have someone who can act as an agent for you there. Is this legal? And then the second part of it is LLCs are expensive to set up and maintain in California, but if I understand correctly, you still have to pay the California fees on top of the other state where you form the LLC. Can you clarify?
I don't know anything about forming an LLC in California, so I don't know. Can you form an LLC out of state and have an agent for you? Absolutely. LLCs are not that expensive. New York, they are not that expensive to form. So, I don't know, if you're hiring an attorney, yeah, that adds an expense. But so again, it's a state by state creature. LLCs are cheaper to operate than, say, a subchapter S corporation or C corporation, subchapter C corporation. So, the corporate, it's a different entity than a full-fledged corporation where you'd have a lot more paper keeping and stuff like that. So the LLC would be easier to do. You could do a PLLC, which is a professional limited liability company. So, yeah, wow, yeah, $800, yeah, that's a lot. But even still, yeah. LLCs are a better conduit for if you're like a single 1 or 2 person operation.
Thank you. Rick?
Well, Terry, that was wonderful. Thank you so much. I got so much out of that, but I'm going to have to go back and review the video to make sure I caught everything. So
No worries. I hope I didn't go too fast. I'm a New York City guy, so we kind of go.
no, that was great. But I want to remind everybody that we will have this on our YouTube channel, and you can get to that by going to our website, and then on the members tab, click on that, go down to what is it, the Capital Crimes videos, and from there you'll be directed to the YouTube. But that was wonderful. We thank you very much for coming. I hope you'll come again sometime because we're going to have
absolutely.
1,000 legal questions.
Yeah, no worries. And please, thank you so much for having me. It's been wonderful. And again, anytime you want to have me back, I would love to come back.
We'd love to do that. That was great.
Thank you.
Well, everybody have a good one. I hope to see you. Let's see, our next time we're together will be, I guess, April. Oh, no, that's April 8th. March 9th and March 10th, we'll have a Meet the Author with Claire M. Johnson. Maybe we'll see a bunch of you at Left Coast Crime, I hope. So have a good day. Have a great weekend, and we'll talk to you next time.
Take care, everybody. Thank you.
Bye.